देखिए, ये साइबर केस में चेयरमैन पीटीआई की दरख्वास्त जमानत है, जिस पर इस्लामाबाद हाई कोर्ट के चीफ जस्टिस सामने ओपन गेट जो कोर्ट में जो है वो समाप्त कर रहे हैं.
If appeal comes to the Supreme Court.
And just a few moments back, the latest development that has come in is that the defense minister has ordered a complete siege.
It would not prejudice the case of that person, and because of the reason that already opinion has been given three senior judges of the Supreme Court.
Lord, my humble submission is it would not prejudice the case of the petitioner because it is merely an administrative decision. It is not just like the single judge in chamber. His order has no judicial precedential value.
Within the parameters of 184(3).
तो ये पार जो है ये registrar जो power exercise करता है, that is an administrative power. The three-member committee would also be exercising the same powers. Previously, they were being exercised by the registrar. Now they'd be exercised by three judges. But there is a judgment of this court which says no. The question whether it is a question of public importance involving fundamental rights, it is a judicial question and has to be judicially decided. How do you answer that?
Lord, my submission would be that even after that judgment, and I think it's 1997, वो PIA वाली recent भी तो है already.
एक से ज़्यादा judgment है.
जी जी बिल्कुल बिल्कुल.
Of appeal in chamber.
But
इसमें कहा गया कि the word used is adjudication. The very word used over here. This is a matter of adjudication.
Those were
judicial power.
Those were orders. The more recent ones are the orders passed by my Lord Mansoor Shah in as single judge sitting in chamber, which is an administrative power.
One of them is even.
But there are judicial findings of this court also on this, and I think that case relates to 1998. But all I'm saying there is, sir, that despite that,
what is
the administrative gatekeeper has continued for after that judgment for 23 years.
वो छोड़ें, हम तो एक्ट को देख रहे हैं.
There is.
तो आप तो हमसे कह रहे हैं कि हम उसको एक्ट में कंटिन्यू करते रहे.
My lord, it has not. All I'm saying is it has not. That aspect has not previously troubled this court so long as it was done by the registrar.
सलाउद्दीन ये जो रजिस्ट्रार के ऑर्डर के खिलाफ अपील सिंगल जज को है, ये अपील की रेमेडी बाय रूल्स प्रोवाइड की गई है.
जी सर.
और इसी तरह ये जो कमेटी बनेगी सेक्शन 3 में, ये भी तो एडमिनिस्ट्रेटिव कमेटी, इसके खिलाफ भी रूल्स में
अगर रूल्स में आप एक अपील दे दें तो
प्लेटफॉर्म दे सकते हैं. देयर नो प्रॉब्लम.
बिल्कुल बिल्कुल सर बिल्कुल. और
अजीज साहब खत्म.
I'm done sir. As for sir, sorry, one last aspect, and that relates to the question that Her Ladyship Ayesha Malik had asked. What is the effect in Section 5 when if a full court is formed or a 9-member bench is formed, etc.? I would rely upon the principle that there is a difference between a statutory provision that is ex facie discriminatory and a provision that may only be applied in future in a discriminatory fashion. The distinction is drawn in Jibindra Kishore, that is PLD 1957, Supreme Court.
It's not a question of discrimination. It's a question of the right of appeal being taken away, full stop.
Yes, that issue also I'll cover. But first of all, jo discrimination wala aspect hai, because Article 25 was said that one person is being denied the right of appeal just because a committee has formed a larger bench. So the other judgment is Shaukat Ali Mian.
It's not just a question of discrimination.
PLD 57 का citation क्या है?
PLD 1957, Supreme Court 9, and PLD 1999, Supreme Court 1026. That's Shaukat Ali Mian.
It's not just a question.
Repeat this. It's 95 Supreme Court.
Sir, 99 Supreme Court 1026.
1026.
शौकत अली मियां का केस सर, वो जो फॉरेन एक्सचेंज.
जी जी. पहली कौन सा?
पहली जिबिंद्रा किशोर का था सर, PLD 1957, Supreme Court, page 9.
Okay.
My question was not only of discrimination, but my question was that it is a substantive right that the law provides. And if the law is to be upheld, then on what basis can the committee deny any person that substantive right? So it's not just a question that some will be allowed and some will not be allowed. The question is then that actually you cannot make a full court or a larger bench because that right of appeal will be denied to a person. And there is no basis to deny a substantive right.
The solution that I will offer, and then I will rest.
Solution तो बाद में आएगा ना, पहले तो जवाब होना चाहिए कि ये हो भी सकता है कि नहीं, फिर solution आएगा.
The answer that I will offer.
You see, the thing is, in practical terms, the 3-member committee, essentially that committee would decide in which cases an appeal would be available and in which it won't be. Because by constituting a bench more than 8 judges, it would deny the right of appeal. And by constituting a bench of less than 8 judges, it would provide a right of appeal. And what is the criteria here?
There are two concerns. One is the past, one is the present. If this law is sustained, then naturally the committee will realize the provision of an appeal and will make an attempt not to do 9 benches plus, okay, realizing that, unless it's a matter of, I don't know, I don't want to state it because it may come to haunt me, but having realized that, so as far as the past is concerned, that's a different matter altogether. So committee being cognizant of this law will try that in 184.3, we do not go and constitute 9 plus benches, or if you don't have enough judges to hear an appeal. That's a simple answer. If the committee wants to close its eyes to it, that's another thing. Then you will say that the fault does not lie in the law, the fault lies in the committee and your
discriminatory application of that law.
Yes.
Now that is why I was citing these judgments, because these judgments say,
for all intents and purposes, a full court and 184.3 can never be made.
Sir,
अब take this case for instance. इसकी अपील चलें, हमने कहा ये दो ही हो सकते हैं ना, असिस्टेंट करें, स्ट्राइक डाउन करें, कुछ लोग खुश नहीं होंगे, अपील कहाँ होगी? तो एक सिंपल जवाब है, नहीं होगी भाई, सबने सुन लिया, क्योंकि जिसने अपील सुनना था वो भी बेंच का हिस्सा थे. अब खत्म करें बात को.
जो जजमेंट्स मैंने साइट की थी वो ये कहती हैं कि अगर कानून ex facie discriminatory नहीं है, मगर it allows for an authority to in future apply it in a discriminatory fashion, then what this court can do is...
I don't like this word discrimination. Sorry, I completely don't like this word discrimination, because you are saying that actually the law, this law, very law, gives you a right to appeal, but then it may be taken away in the future, so it is discriminatory. The other argument would be, the other simpler argument would be that if there is no appeal, then it's all right.
What happens to the right of appeal then?
Mr. Salahuddin, the very fact that this law, every section, argument is being made, this can be read down, this can be read up, this can be ignored, this can be taken up when the situation actually occurs. That itself shows how defective this law is.
As far as I'm concerned, there are only 2 issues that I've highlighted.
पहले ये appeal के context में, there are 15 judges. All of them are hearing this case. And in any case, the appeal would also lie to the same court, to the same judges. What prejudice would it cause if a full court hears it? No prejudice would be caused.
My lord, my case would be, my case is that if a full court is constituted, then every judge of this court has been heard, then any right of appeal is illusory, the loss of that.
So then we just ignore the law, we just
ignore
ignore the substantive law for right देने का. But you see, when you are arguing a point, you have to keep in mind that you are arguing, you are saying that because all the judges are sitting, so that right which is given under the law, that is just an illusion now because all the judges have heard the case. So what happens to that person who says, where is my right of appeal? How do you explain that to him कि ये तो एक illusion है जी, सारे judges ने सुन लिया इसलिए इसका मतलब है आपका case बंद हो गया. So then the question is कि वो right block नहीं हो रही, वो arbitrariness नहीं होती.
I'll address this question. All I'm saying is that to read section 3 and 4 and 5 harmoniously, your lordships can lay down guidelines even for the committee, that the committee will consider that the right of appeal should not be snatched away from anyone. However, where a full court is constituted,
section
that
3
issue
में,
becomes
Mr. Salahuddin,
that is my
section 3 में not less than 3 judges है, ठीक है? अगर कमेटी ने कहा कि इसको फुल कोर्ट में जाना चाहिए, तो ये कमेटी डिसाइड कर सकती है, नहीं कर सकती?
कर सकती है।
अब आप अपील में अगर
मगर 9 से 15
15
के दरमियान
listen, कमेटी में कॉन्स्टिट्यूट द फुल कोर्ट और नॉट, कमेटी में कॉन्स्टिट्यूट, वो कहते हैं ये इतना इंपॉर्टेंट क्वेश्चन है कि हम समझते हैं कि पूरे फुल कोर्ट को सुनना चाहिए। अब आप अपील में जब आएंगे,
you have yourself said, this was the point I was going to ask you, कि आपकी थ्योरी के मुताबिक 9 to 15 नहीं हो सकते।
उसमें मैं हार्मोनियस इंटरप्रिटेशन कर रहा हूं।
या 7 सुनेंगे मैक्सिमम या फुल कोर्ट।
और ये अपील में भी जो राइट है सेक्शन 5 में,
because it does not discriminate with anybody in that case.
Mr. Salahuddin, Salahuddin साहब, अपील सेक्शन 5 में जो है वो फुल कोर्ट अगर बनता है तो अब यहाँ पे अपील करनी है कॉन्स्टिट्यूशन टू ए लार्जर बेंच। अब जब फुल कोर्ट ने अपील सुन ली तो लार्जर बेंच तो आपके पास है ही नहीं। तो ये इसकी एक स्लाइटली जो एक अंडरस्टैंडिंग है, जो व्हाट आई कैन अंडरस्टैंड।
Yes, sir, exactly.
अब पता नहीं इसकी अंडरस्टैंडिंग आपकी डिफरेंट हो सकती है।
No, that is exactly my understanding, sir.
बस let's stop it at there. लिखिए इसमें Mr. Abid Zuberi, नहीं, notice was issued to the Supreme Court Bar Association, and Mr. Abid Zuberi, President of the Supreme Court Bar Association, on behalf of SBCA, states, refers to CMA 82772023, filed by SBCA, full stop. He has completed his submissions in and states in opposition to the act. इसके बाद थे CP number 33. CP number 33/2023. We've heard Mr. Adnan Khan, learned ASC, on behalf of the petitioner, and say वो रिव्यू वाला सिर्फ कहते ठीक है, बाकी गलत है ना? किधर गया अदनान? Where is Mr. Adnan? जी
वो चले गए, नजर नहीं आ रहे सर।
ये तो देखिए, अब आप ये देखिए आदिज मैनर्स, अभी वो चले गए, मैं थक गया, मतलब हम बैठे उनके लिए और वो चले गए। अब चलिए, has concluded submissions. CP number 18 का लिखें, filed in person.
हमारी आपकी petition बताओ।
ये किसने फाइल की थी? आपने। And by learned ASC of this court, and he has completed his submissions, which ASC नहीं है, states as an advocate of the Supreme Court, and he's been heard in his private capacity. अच्छा, this concludes submissions made by all. Made by all those opposing the act. Full stop. Mr. Next paragraph लिखते हैं. Notices were also issued to political parties, and Mr. Zahid Ibrahim Learned ASC states that he represents PMLQ and has filed CMN 3991/2023. यही आपने फाइल किया था ना? Full stop. And he has concluded his submissions. Thereafter, we heard Mr. Salahuddin Ahmad on behalf of PMLN, whose filed CMA number 8301/2023, and Learned Council concluded his submissions. Full stop. It is now 5:40. Adjourned to कल की तारीख डाल दें at 11:30. 11:30.
सर जमात इस्लामी पाकिस्तान की तरफ से
किस तरफ हैं?
मैं सर जमात इस्लामी पाकिस्तान की
किस तरफ हैं?
जी सर मैं जी सर इस एक्ट के हम सपोर्ट करते हैं मतलब गुलाम मुहिउद्दीन साहब
अच्छा, the only party which is not represented, or significant party rather, is the Pakistan People's Party. Mr. Farooq Naik is, I'm told, that was appearing but then has stopped appearing. So then, no point of view of the Pakistan People's Party, a major political party of the country. अच्छा, चलें, खैर, can't force anybody. नहीं, वो जमात इस्लामी तो सपोर्ट कर रहे हैं ना, लॉ को सपोर्ट कर रहे हैं। आप भी सपोर्ट कर रहे हैं ना, तो आपको कल देखेंगे जो
सबमिशन इन राइटिंग हैज बीन फाइल्ड सर।
अगर आप मजीद कुछ नहीं कहना चाहते,
कुछ नहीं कहना
आप दोनों ने
अच्छा
इनका लिखिए।
आपने कहना
नहीं सर,
अच्छा
भी कुछ नहीं
जो भी इन फेवर आर्गुमेंट्स
मिस्टर सैफुल्लाह कौंडल।
जी सर, जी सर।
मिस्टर आप एएससी हैं या नहीं?
नहीं सर, मैं मरकजी लीगल कमेटी का मेंबर हूं जमात इस्लामी
आप
पाकिस्तान।
वकील हैं क्या हैं?
Moinuddin, I think
advocate
advocate
and states that he is a member of the Central Legal Committee of the Jamaat-e-Islami and that he has filed, कुछ फाइल किया आपने?
जी सर।
कुछ फाइल किया है?
नो सर।
अच्छा, and states that he supports he supports the act.
करते हैं सर
He supports the act. Full stop. इसमें लिखिए Mr. Kamran Murtaza, learned ASC, represents Jamaat-e-Ulama-e-Islam. हाँ?
जमीयत-उलमा-इस्लाम पाकिस्तान सर।
अच्छा, पाकिस्तान भी लिखते हैं?
पाकिस्तान
JUI पाकिस्तान। एंड आपने कुछ फाइल किया है?
मैंने फाइल किया।
And you has filed CMA number?
Just giving sir.
So and so, and CMA number 83192023, and states that this his submissions are contained therein in support of the act and does not want to add anything further, save adopting the submissions made by other legal counsel who are in support of the act. ठीक है? तो अब कल adjourn to कल की वो टाइम लिख दीजिएगा, कल का वक्त देंगे 11:30 बजे। जरा जल्दी कर लें ब्रीफ, ठीक है? कुछ सुनाई नहीं दे रहा है। आपके तो लिख दिया ना?
हो गया वो। अब इजाजत वीडियो लिंक ही दे दीजिए ना लाहौर से। लाहौर से अब इजाजत दे दीजिए वीडियो लिंक की लाहौर से। मैंने आर्गुमेंट तो
आप बैठ करके सुन लीजिए, मुस्तफीद होइए इतने बेहतरीन आर्गुमेंट से, मगर हम आपको सुनेंगे नहीं वीडियो लिंक से। आप बेशक वीडियो लिंक से बैठ के सुनिए।
माय लॉर्ड ओके ठीक है,
हमने पहले कह चुके हैं।
माय लॉर्ड
चलें।
माय लॉर्ड आई एम ऑन कोर्ट नोटिस। I'm on court notice. I represent the MQM. I'll begin my arguments tomorrow.
ठीक है, आप आपस में, if you all can work it out, who'll go first, who'll go second, rather than.
Sir, it's up to your lordship.
No,
lawyers can never
we
work
have no
it out.
issue. Like today, Mr. Zahid Ibrahim decided to go first.
No. Because he was senior, that is why. And Salahuddin had come before in the case.
He's senior to you?
No, Zahid Ibrahim is senior, sir.
Okay, I didn't realize that. Okay, I thought you were senior. Anyways, आपस में आप तय कर लें, अगर कोई मसला हो फिर देख लेंगे हम।
Sir, your lordship may decide whoever goes first.
ठीक, okay.
पाकिस्तान बार काउंसिल भी है my lord।
11:30 बजे। After regular board, हाँ?
Very grateful, my lord.
Thank you.
Quite consciously, the framers of the Constitution did not subject it.
How does this advance your case?
My Lord, quite consciously, the framers of the Constitution did not subject it.
How does this advance your case?
My Lord, my case is that in 191, on the other hand, clearly a fetter of law has been imposed on the right to make rules.
2043 is also
same. जी बिल्कुल जी सर बिल्कुल and there are other provisions of the Constitution where